Thank you very much. Thank you all for being here today. In the last hour, we heard some shocking testimony, and I'm still trying to wrap my head around this because it's just so unbelievable to me that the government would authorize and grant a refund on fertilizer tariffs for shipments that were in transit. It was authorized and refund, and then took it back after the company had already given the money back to the farmers. And then have the audacity to ask for interest on top of the money that they're asking for back. It's just so unbelievable. So I'm curious what power grants the authority for the department to do that, and is this action even legal?
Thank you, Mr. Chair. So the Canada Border Services Agency, unfortunately, is precluded from speaking to specifics of individual importers or individual importations due to the provisions of Section 107 of the Customs Act. However, I can speak in general terms about the customs duty regime and how the assessment and reassessment process works.
Sorry, could you tell me then was it the CBSA that made that determination?
I'm sorry, the determination, the assessment of duties, or the
reassessment and asking for a refund after the refund was given back to the Solio, for instance, and then asking for the money back.
Again, I really can't speak to the specifics of any individual import or individual importation. I can speak in general terms about how the assessment, reassessment, refund process works, if that would help.
Sure.
So the customs duty regime in Canada is based upon self-assessments at its foundation. So an importer, upon importing goods and accounting for them, will self-assess the amount of duty owing based on the tariff classification, the origin, and the value of the goods. Following that, if they've overpaid, they can seek a refund. If they've underpaid, of course, they can make an adjustment request to pay the difference. Following that refund, and in general, just as a broad principle, the CBSA maintains a risk-based compliance approach, which involves reviewing both individual self-assessments upon import, but also refund requests to review and determine if they are accurate. On occasion, additional information comes to light, which indicates that there may be an issue with any individual importation or any individual refund. At that point, normally, in general, additional information can be requested from an importer. Based on any additional information that's provided, we will make the CBSA will make a redetermination. Following that, if the importer disagrees with whatever that redetermination is, they have the legislative right to appeal, either initially to the CBSA's recourse directorate, which ensures an impartial review of whatever decision was made. Following that, there's additional levels of appeal both to the Canadian International Trade Tribunal and to a federal court of appeal. The ultimate goal of the CBSA in assessing duties and taxes is to ensure the accurate assessment at the end of the day of whatever duties are owing.
So does the minister have direct oversight on this kind of a decision? Would the minister have made that order in this particular case when we're talking about fertilizer tariffs here?
Again, I can't speak to individual importations or individual decisions, but as a general rule, invariably, the decision-making authority is delegated down to the individual officer level when it comes to duty assessments, reassessments, and refunds.
We're the only G7 country that is applying this tariff to fertilizers, and we can say the EU and the US have tariffs as well for domestic industry protection, but not as a retaliatory measure like in Canada. So why fertilizers when there's an exemption for steel and aluminum, for instance?
So the way that it works with the provision to withdraw MFN, it's a horizontal provision. It's done through order in council, and it is effective for 180 days and can only be renewed upon the agreement of Parliament. And for Canada, what applies when you withdraw MFN is a 35% general tariff that applies to virtually everything. There's a very narrow set of products that aren't included, things like, I believe, art objects. I don't know the exact ones, but not anything significant. So steel and aluminum were also included in this. This is in contrast to certain other countries that might have a more variable rate that applies when they take steps. And of course, theirs are structured differently within their law. It might require legislation, et cetera. So part of the reason was simply that it was a horizontal measure done through order in council and applied broadly.